We're talking about adjustment of status applications at ICWC on July 7th, 2017. So the law for adjustment of status for U visa applications is codified in INA 245M. Those of you who know something about immigration law know probably that most adjustment is under 245A, which is a lot more restrictive than 245M. So we are very, very lucky. And it requires that the person has been in the United States for at least 3 years in U status. So U1 is the principal, U2 is the spouse, U3 are the children, U4 are the parents of a minor applicant, and U5 is the siblings of a minor applicant. The principal applicant cannot have unreasonably refused to assist law enforcement after getting their U visa. That's almost never relevant. And even if it were, it's not to the derivatives, only to the principal applicant. Has to be justified by humanitarian, family unity, and or public interest grounds, which is super vague and which it's not too hard to prove. And they can't be inadmissible. The only inadmissibility factor that makes somebody ineligible for adjustment also makes them ineligible for U visa, which is Nazi persecution. We don't have a lot of those. In addition, although it's not in the law, the Immigration Service requires that somebody have a valid passport throughout the period of U status, but they forgive that if the person has a passport when they do apply. So a lot of times, so many of our declarations will say, I didn't know I needed one. As soon as I found out, I got one, and those have all been approved. One of the little problems that we have, nope, I'm not getting into details at this point. Okay, so if there is a period without valid passport, we just get to explain it, not a big deal. The process is that everyone has to apply. So with the I-918, the principal applicant applies for U status and then is the petitioner for each of the applicants, so the I-918 supplement A's. But in this case, everybody is their own applicant, and they have to each individually be eligible, so they all have to have been in continuous residence for 3 years or more at the time they submit their application. So a person doesn't become eligible for adjustment of status until exactly 3 years after they got their U status granted, which is why right now Cami and Elena are going crazy trying to prep for all the people who are going to become eligible on October 1st. Because a lot of work, and so we want to be sure that we're able to get everybody out by then. And it's adjudicated at the same place that U visas are, which is wonderful news also. As I noted, there is only one inadmissibility ground that makes people ineligible to adjust status. And they cannot get a waiver of it, but every other thing is either the waiver that somebody got when they were applying for U status. We would just refer to it and say, this happened, I requested a waiver of it with my application for U status, and since then I've been just nothing but good. So that's all we do for that. But then if they've committed something after they were approved for U status, and we have to overcome that, we had to ask for discretion. We've gone back and forth with the Immigration Service about whether we can submit a new I-192 at that time. To me, it doesn't make sense. If the person's already in U status, they don't need a waiver to get a non-immigrant visa. And Immigration has gone back and forth about whether it's okay to submit an I-192, but they will always let us just argue that it's in the public and national humanitarian interest for the person to get the relief. We use basically exactly the same standards that we do to support a waiver of inadmissibility at the U visa stage. We just do it with the language of discretion rather than a waiver. Okay, continuous physical presence is the thing that will drive everyone mad, because although our U visa approval video that everybody who's going to be coming in, it's very clear and says start collecting documentation that you've been in the United States for all this time, and yet people always forget. as it says here, you can't show that you've been continuously resident. Oh, good. You can't show that you've been continuously resident if you have a period that was broken by an absence of 90 days or more, one absence, or in the aggregate in that 3-year period, 180 days or more. So that's why when people want to travel, if they're in U status, we're always really nervous about it, and because we're afraid that they will break it. However, I will also say that if there's a good humanitarian reason for extending their status, immigration will do that. And so it's not the end of the world, but we want people to think it's the end of the world because we don't want people traveling. So to document it, as I said, is maddening. This is the sort of thing that we're telling people to include. We want, the reason that immigration wants somebody to have a passport throughout the entire 3 years is because then that proves that they haven't gone through inspection, or they haven't had it stamped. It's really not very good proof because there's so many ways that you can go and come back without having a stamp in your passport. But that's why they want it. Any kind of the highest quality are governmental documents like school records of children, and bills, employment records, income tax returns. But what's so frustrating is that immigration only treats it as a document for the date that it was signed by the applicant. Whereas you're like, they filed taxes, they were here the whole year. But we really want people to save their W-2s because that's the best proof. Monthly rent receipts are good unless somebody has them all made up at the same time by somebody, by getting a receipt book. And you can tell because all of them are in the same order. Or I got some recently that were in reverse order. So pretty clearly fraudulent in that case. Utility bills are good, but they can also be, you can get them fraudulently by registering a wrong address. Why is somebody going to do that? I don't know. Why is this even a requirement? I don't know. But especially if you're submitting utility bills, immigration wants several kinds of different documentation. And I think I've got bank records. I don't have bank records here. They are the best, especially when somebody's buying stuff with a credit card, and we have, gas station in San Pablo, California was accessed on this particular day. And don't worry, we have a lot of this all written down in various other places. We're just doing an overview now. So then, as I said, it's discretionary, and so it's the burden of the applicant to show that they should be allowed to adjust their status. If there isn't some bad thing that's happened since their U visa, there is no reason that it's not an easy thing to get. So we have to say it in the cover letter. And then in the applicant's declaration, which is like a 1-page document, they have to say, here's the ways in which I'm good. And Manny is an amazing master at getting that information out of people. And then if there are negative factors, then you're going to want some additional equities, like, to show you've been attending church or that you've been helping out at your kid's school or something like that. So that's something that we'll work on as cases progress. So we don't really have to go into this level of detail here, but essentially what you're going to want to do is outweigh something with something on the other side. And if there aren't any negative factors, you just say no negative factors. Or another time that we realize we have to ask for discretion is that we, or much more commonly because we're the best, but we still made mistakes, we didn't adequately waive INA 212 A9B, the 10-year bar, because we were waiving 9C, and we were like, oh, well, that kind of, lesser included offense. No, we forgot to do 9B. Sometimes we weren't waiving alien smuggling because of an interpretation in the general immigration community that if you come with your child, you're not smuggling your child, so we weren't including that. But now we want to be, we want to make sure that it's waived. So we just ask for, we say in our cover letter and in the declaration, these couple of things, and and here's how I'm good, and I think it's in, please take this into account when you're adjudicating my application. So the serious negative factors are serious crimes, repeat crimes, or recent criminal activity. And you have to work really hard to overcome the presumption against bad moral character in those cases. We have somebody who, his mom called in and said that he was arrested with 2 pounds of marijuana in his car, and somebody else who was arrested for possessing brass knuckles. So both of those are fair. Yeah, I know everyone's going, why not? But it's a weapons offense, and it's a felony weapons offense. So both of those kids were charged with felonies, and we applied for them much later than the rest of the family because we were making sure that they did volunteer work, helped out in the community, everything they possibly could. So we tried to give the best case we could, and we'll just see how those get adjudicated now under the Trump administration. But it's a little scary. So really, people shouldn't be doing these things. Also, there is this requirement of no lack of helpfulness. However, if when they applied for U status, their I-918 Supplement B, and I'm sorry that we're showing you this first, and so I'm asking you to keep all that in your head till you're working on U visas. There's a little checklist on the form that says, is the investigation ongoing or is it complete? We really push to put complete on there because if it's ongoing, immigration has the right to request a new I-918 Supplement B. It's not, it's a drag, and it's a drag for us, but it's a drag for law enforcement. For AOS. So if it was still ongoing, we try to minimize the number of ongoing ones, and we put it in the declaration. And we say, it was ongoing when I submitted my application, but I've never been contacted since. We do not want to ask the Oakland Police Department that has to process 30 I-918 Supplement Bs a day to have to do some that are worthless. So we will just do it in the declaration, and then if immigration doesn't like it, then we can ask for it then, if they issue us an RFE. We just state it as strongly as we can, and sometimes with a lot of factual details. What were the circumstances under which the investigation was still open, or the prosecution was still open, and how they weren't needed again. Sometimes we just have to do it. And you're also supposed to show that you didn't unreasonably refuse to cooperate, but that would only happen if there was any evidence that you did refuse to cooperate. So if you get an I-918 Supplement B from the Alameda County District Attorney, which you won't get because it takes them a year, then if it said no, she wasn't helpful, then the burden would be on the applicant to submit the 918 saying she wasn't helpful and and evidence that it was a reasonable refusal to assist. We've never had that situation because we are pretty hard-ass with our clients. This is what I already said. To show that they were no longer needed, we don't need the form, we just say it in the cover letter and in their statement. If it was needed, we say, we try to just give a good explanation in their declaration, like I just said. And if they ask, we also have to get something from law enforcement, and usually that's going to be an I-918 Supplement B. It's very rare, though. Okay, this is how to document that their refusal to assist was reasonable, but we don't have to worry about it because we don't get into that problem. So now that we're going to start doing the application, it is G28, which means that we are representing the person. The basic adjustment of status application form is the I-485. It has a fee, so we have to submit a filing fee request. And then one of the more difficult documents is a medical exam completed by a designated civil surgeon. And when people, you guys are you already saying that they're going to need it in the start packet?
I don't think so, no.
Okay.
No, it doesn't say.
I'm going to wave this around in front of here. Here's one. So there's a list on the USCIS website that says where designated civil surgeons are, and it has to be through one of them, and you have to check very soon before, because they change sometimes. So you really have to send somebody you have to have looked within, a week or two before assigning them there. And we'll go more into that in a little bit. And maybe a supplement B. And then we often want to submit an application for a work permit in category C9 in case the person's U visa expires and their work permit expires before they get their green card. And that has so much to do with how long it takes immigration to adjudicate. And when they take a long time, we want to be sure to get that. Fortunately, the C9 I-765 receipt serves as evidence of authorization to work, so we don't have to do it like way in advance. And so I just want to take the opportunity to say here that the U status is automatically extended when the I-485 is received. So so they don't have to worry about specifically staying on top of that. The only thing that they're going to worry about is whether they have a card that shows that they're still eligible to work. And that's why we do the C9 one. So for supporting documentation, their approval notice, all passport pages, and Elena knows how to make those. I think, yeah, a bunch of us do. We have an ID function on our copier. And then their declaration, which will help them write, and their continuous presence. And as it says here, we try to get one document for each 3-month period. And what's great is when they bring them in for every month, and then we get to
Is there an actual form for the CPP, or is it just the collection of them?
It's just the collection. And we used to list them in the cover letter, and lucky everybody who's going forward, we've decided to stop doing that because that is a pain in the neck. So some of the special issues, as I said, we'll need a supplement B if the case was open when it was filed. Although now that Julie's here, I will point out that we don't automatically request a supplement B just because the case was still ongoing when the application was the U application was filed. We make them ask us for it because we don't want to harass the police departments. And at least half of the adjudicators, if they read a statement that says they didn't ask me for help again, that's enough. It's only about half the adjudicators who do give you a hard time. So if the I-192 was insufficient, as I described before, or there's additional problems, you also have to submit additional evidence to show that they are deserving of approval. And if they ever left the United States, we have to, while they were in U status, we have to show that they re-entered lawfully, and evidence that they were under 90 days or for each one, or 180 days in the aggregate. So the procedure, as I said before, it's filed with the Vermont Service Center, which is great because they understand that it's a little harder for crime victims and their family members to keep documents than for other people. After we file it, they get a biometrics appointment, and we will get that here and send it out to people. And they have to attend, but if they don't for some reason or another, they can go in anytime with that same notice. The Oakland office is a little crankier than other offices, but I have a contact there now, so we can force them to accept it. And then they get their approval notice, and shortly thereafter, they get their green card in the mail. And their permanent resident status is recorded as of the date that it was approved. So usually about 5 days earlier than we get the card. And then they're eligible for naturalization after 5 years in permanent resident status. Okay. People, so I think a lot of people, you guys have been exposed to this a little bit already. If somebody was not married to her pareja when she filed her I-918 application, she was unable to include that person as a derivative beneficiary of her I-918. But there's a whole provision for permitting U1 petitioners, not any of the derivatives, not the U2 through 5, but the U1 petitioner can submit an application called an I-929 for a new spouse. But she has to be married to that spouse on the day that the application is adjudicated. So we force them to get married before we will even submit the application. Because what if there was some emergency and USCIS caught up and adjudicated their application early, then they wouldn't have been married at the time the application was filed. So that's why we want people to be married to their intended person beforehand. Sometimes they will have a child that they didn't petition for before. We have one case where she wanted to, but the child couldn't get their passport, and so they couldn't enter the United States with their derivative status. So now she's having to do a 929 for him because he's over 18, and so he can get a passport. His father wouldn't support his application for the passport. He was also the abuser. That person has to have never had U status. So in this young man's case, he was approved as a derivative applicant, but he never entered the US, and so he was never in U status. So he's still eligible for that. You have to show extreme hardship both to that family member and to the U1 applicant, holder, sorry, if that person can't be approved for this status. And we're not going to talk anymore about the I-929 today. We'll do another training on those then. One of the important things, though, is that the person has the I-929 is just like the first stage of the process. After it's approved, that qualifying family member has to apply for a permanent residency, either in the United States through their own adjustment of status application, which takes forever. For those 929 based AOSs, they take like more than a year and a half. And so that all has to be accomplished before a child turns 21. So if the qualifying family member is a child and is outside of the United States and is over 18, we're going to be having to freak out and really push for them to be able to get the 929. Well, first, the U1's adjustment of status has to be approved, and then the I-929 is adjudicated, and then the permanent residency application, which, if you're outside of the United States, involves consular processing. So it's a really long process, so that's why we're cautious when, well, this is Cammie's job to say, how old is this person that we're thinking about? Also, a stepchild can be petitioned for at this time, but it's difficult because you have to show that it would be an extreme hardship to the U1 holder if the person, if that stepchild couldn't enter the United States, and if they've never even met, that's a higher bar to make. Okay, here we are doing it the ICWC way. We start 3 months before the person is eligible so that they'll have enough time to be able to gather all the documentation that they need. It doesn't have to be 3 months. It's just that we want to spread all that out so that we're able to get everybody submitted as early as possible. So Camila or somebody else in her stead will do preguntas iniciales, where they just find out whether the person, when they become eligible and when they, and whether they've left the United States, whether they've committed any crimes, whether they're married, whether they need to bring their derivatives in with them. And then Cammie will mail them a start packet, and she brought me one, but I haven't made copies of them, but I will give them to all of you. And that gets people so well prepared to come in. I swear, before we had these start packets, it would take people forever to get all their continuous presence or to get their fingerprints taken and all that. And fingerprints are a pain in the neck because they have to go all the way up to Red Tomatoes to get them. And so a lot of times, if we're telling them in our office, they're like, oh, I'll do that later. And since we need the FBI results to be able to go forward effectively with the case, we really want to have those fingerprints in as soon as possible. So that is wondrous. And what will happen is then when she schedules them for the appointment, they have an appointment notice right there saying, here's when your appointment is and here's what you're going to bring. And most people really do bring that. So when they come for their appointment, is this it? I thought I have it somewhere. I'm going to jump ahead. Oh, there we go. Oh, look at that. That was just an introduction earlier. I'm going to jump ahead to the start packet, see how that's here. And now right before, so then the person will come for their appointment and they will sit in the waiting area and they will complete a red flag checklist that asks things like, have you been arrested, were you divorced, have you committed any immigration violations, have you been outside of the United States too long? So they'll be filling that out for us. But they'll first give us all their documents. So we have a chance to flip through their documents and see what's still going to be needed, which is very nice when you're doing an intake appointment. You want to, feel like you're on top of it rather than having to deal with too many things at once. So we usually have the person take about 15 minutes to fill out that red flag checklist, and so you'll have that much time to kind of get to know things. That doesn't mean you need to be making copies during this time, because then you won't be able to have calm and peace when you're starting to talk to people. So once they come on in, what we're going to be reviewing in those documents is that did they bring their fingerprint cards, do they have their worksheets that we sent them, and do they have continuous physical presence documentation, and did they bring half the payment. Now if they didn't bring all those things, we aren't going to turn them away. We're just going to say, don't forget these things are important to bring. And then we will write each of those things on the doc list that you'll give them in that first appointment. In the first appointment, we explain the process, and we have a proceso sheet, and we have one for the 929 also. And so you go through point by point what's going to happen in our process and in the immigration process. We'll tell them how much their fees are. Should say somewhere here that they're going to be signing a retainer. We'll go over their red flags with them, explain the medical exam requirement. And there should be the intake form in here. Oh, there it is. The intake form. It is a long intake form, and I have copies for all of you, but nope, I only have one main copy, but I will be making them all for you. You can see it is super, super long. I think it's 9 pages. And the idea is, once we have all this information from someone, we can really assess carefully what their eligibility is and whether there are any red flags. So they're filling out the red flag checklist just to make sure that we like to have is, we're going to ask all those questions again, we just want to make sure that we get them, because sometimes people don't understand when they're being asked in one context, and then they do later. So that is the main part of this first appointment, is the intake guide. Crystal and I are going to have a different plan because where the intakes are done by the attorney, and the rest of the process is done by a legal assistant under the attorney's direction. But because I can't do intakes because I'm not a Spanish speaker, we're going to have a hybrid system that you and I will go into little by little. So then we go down and we go down the document list of things that they're going to need. And we highlight things that they need, but they should have brought everything. Most people already have brought everything except the medical exam, because they don't take the medical exam until we tell them to take the medical exam. Medical exam is only good for a year. You have to submit it within a year of when it's been taken. And then once it's submitted, it's good for another year, which that's why we really hope that immigration adjudicates those things within a year. And then we explain the 929 process. Caseworkers don't have to collect the payment because that's going to be done at the front desk. And then here's what the client has to do. They have to get their medical exam. They have to get their fingerprints if they didn't already do it. Oh, and then here's a caseworker thing to do, but it's also in the next slide. We do the online FBI request, which we'll show you all how to do, which is wonderful. And then when we get the FBI results, we call her and we say, if she hadn't already filled out all these forms, be sure to do it, because now that we have your FBI results, we're able to go forward and have your next appointment. We also sometimes, what we have people do is send in the worksheets if they didn't already fill them out before they came. So we just try to smother them with the importance of bringing those things. And this says complete the G28, I-485, and G325A forms on Abacus. That was the one where I forgot to delete G325A. The new 320-page I-485, actually I think it's only 18, it includes all the information that used to be on form G325A, but because our worksheets together you know, that will kind of make what most of the new 485 is. That's why we're using those worksheets now until we're able to redo it and retranslate it and send it to people. Not all of the questions that we need at this stage are currently going to be answered on the worksheets that we're sending out right now. And we hope to have that translated within the next week or so, and that's what we'll be sending out. So they have to get the medical exam. We already talked about that a little bit. Let me show you where to find that. I have a step-by-step how to do these, and in that, oh, there it is. Oh, it's right there. Never mind. You don't need me. Slideshow from beginning. Oh, no. Whew. All right. This is where you find out who the close by civil surgeons are. We really recommend that people get their vaccinations updated and get lists of the vaccinations they already had from their regular practitioner, so that the designated civil surgeon doesn't have to do those vaccines, because they charge more because it's like a captive audience. For the past year, a gonorrhea requirement was added to that, and the main doctors that we refer people to in Oakland either do it very cheaply, or they have other funding like Medicaid or something, Medi-Cal, that they can do it under. So that hasn't been as big a burden as we were afraid it would. Most civil surgeons require 2 visits. One is for the appointment where they do the physical exam, and the next one is for picking it up. La Clínica requires 3, because the first one you pay, and then once you've paid, then you can make an appointment, and then you pick it up. Sometimes people will test positive for something. Tuberculosis is the most common one, and they'll have to get referred out to get a TB, to get a chest X-ray. Yeah, and then they bring that back to the designated civil surgeon, who then writes what happened as a result of that. And I will show you in a few minutes what all is in that medical exam form. But this is the hardest thing, I think, for clients, is to get that, and the most expensive also. So what we're supposed to do is confirm everything that from our intakes into all of the abacus notes. And again, one of the places that we're going to be looking for a lot of these things is we'll go into the old U visa case, and we have a lot of information also from their approval forms, like, you know, what their date of birth is, and so we have a lot of ways to cross-check. And then we'll write an abacus note that includes basically what their eligibility problems are, and for each person, and when they're planning to bring, what they're planning to bring, and when they're planning to bring it. I have much more in-depth instructions on those notes in our practice materials. So, and then we send off the FBI, and then we enter the results in the FBI note, unless whoever's sitting at the front desk is extra helpful that day. And then if there's something comes up in the FBI, then we consult with the reviewing attorney to see if that's going to be a problem that's going to require additional documentation of good moral character with the adjustment of status application. And then before the second appointments, we will make sure to have entered all of the information from the worksheets into our abacus forms. And then we write what we still don't have, and then when we schedule that second appointment, we'll say, remember, we don't have this, bring us this. And then in the final appointment, we collect everything that they've brought. And at some point, I guess I said we're going to make copies of that, of all of the pages of their passport. So we review everything, and then they look over the application forms. You can do it with them. You can, like, if you have it printed out, you can put it on the table facing them and point to what each question is and what they've answered on it. With the biographical stuff, I just have them look at it and to say, yes, this is my address, or no, that's not how you spell my name. It is wonderful to have them as proofreaders. And then, so they're going to review each of those forms. And then you work on the declaration. And then if they didn't bring everything they needed, you can make another document drop appointment. Document drop appointments are good because they're with the caseworker, and they by the fact that it's an appointment, it means the applicant takes it more seriously. But we don't want them just to drop things off at the front desk or the intake coordinator, because it's the caseworker who knows what's needed, and this allows them to have the time to be able to devote to getting that stuff from the client and determine whether it's enough. And then again, front desk staff will get the final payment. So here's the declaration. So nice. We have an outline for it already. And do you know if the current outline is what we want? Sometimes we want little changes, but I think it's pretty good now. And it basically says for the U1, I was a victim of crime, I was helpful, I've never been asked for assistance since the application was filed, I haven't left the United States in all this time, and I'm submitting documents to prove that, and I'm a good person, and it would cause me hardship if I had to leave the United States. I need the protection of the U visa and adjustment of status. Super easy. We just modify it to describe whatever is unique to them. Then for the derivative, they can't say I was a victim of crime, but they also say I have never been asked for assistance in the case of the principal applicant. And they always say, but if I were to be asked, of course I would be helpful. Oh, that's the end of the slideshow. Okay, so now I'm going to show some. Oh, it's already past 11. So this was the quick overview. So people who got the quick overview. Oh, that's right. We're until 11:30. You can leave if you like, or we can just go through the next stuff now. Okay, all right. I'm going to force you out, and then I'm going to go over just with Julie and Crystal the kind of nuts and bolts stuff.
Thank you.